am Ace Patrick Rizaldo, and I'm very delighted for this opportunity to be with you. And so for today's video content, I will present to you all about real property. Real property is a legal term encompassing ownership interest in real estate or immovable property. It is a type of property that differentiated from personal property. Real property can also be held in some various ways. In some jurisdictions, real property is held absolutely. Real property is not just the ownership of property and buildings. It includes many legal relationships between owners of movable property or real estate that are purely conceptual, such as the easement, where a neighboring property may have some right on your property, right of way, or the right to pass over a property, and incorporeal hereditaments such as profit and a prendre. In England, it may still be considered to be carved out of Crown's ownership of all property in the realm. Such distinctions are important in terms of the law is cheap or when property reverts to the state because it lacks an owner or has been abandoned. Let us proceed to the historical background of real property. In law, the word real means relating to a thing as distinguished from a person. Thus, the law broadly distinguishes between immovable property, which is the land or anything that is affixed to it, and personal property, including everything else such as clothing, furniture, and money. The conceptual difference was between immovable property, which would transfer title along with the land, and movable property, which a person would retain the title to. In modern legal systems derived from English common law, classification of property as real or personal may vary somewhat according to jurisdiction or even within jurisdictions according to purpose, as in defining whether and how the property may be taxed. In modern legal systems derived from the English common law, classification of property as real or personal may vary somewhat according to jurisdiction or even within jurisdictions according to purpose, as in defining whether and how the property may be taxed. Now, this report discusses the ownership of land using the interpretation of real property as a legal term used in Anglo-American common law jurisdictions. Other legal geopolitical systems of government have different legal interpretations concerning the ownership of land. Terminology varies in these systems as well. For instance, heritable property in Scotland, immovable property in Canada, United States, India, Malta, Cyprus, most of Europe including Russia, also South America, Malaysia, South Africa, Pakistan, Bangladesh, and many other countries and continents, and immobility in France. Estates may also be held jointly as joint tenants with rights of survivorship or as tenants in common. The difference in these two types of joint ownership of an estate land is basically the inheritability of the estate. In joint tenancy or in marriage, this is sometimes called tenancy of the entirety. The surviving tenant or tenants become the sole owner or owners of the estate. Nothing passes to the heirs of the deceased tenant. In some jurisdictions, the magic words with right of survivorship must be used for the tenancy will assume to be tenants in common. Types of ownership interests. Fee simple or freehold. The most common interest or right in real estate and provides the owner the right to use the real estate for any lawful purpose and sell the interest when and to whom the owner wishes. Life estate. It is an interest in real estate which is granted to a life tenant until that person dies. During the life estate, the life tenant has the right to use the real estate for any lawful purpose but may not sell the interest. Estate for years is similar to a life estate, but term is a specified number of years. Leasehold. The right to possess and use real estate pursuant to the terms of a lease. Reversion. Reversion is the right to possess the fee in interest in real estate after the expiration of a life estate, estate for years, or leasehold. Concurrent or co-tenancy. It is an ownership or interest in real property by more than one party. Rights of any single party may be limited in various ways depending on the jurisdiction and type of concurrency. Note that this is possible for a property deed to further restrict its general ownership rights. Now, there are forms of concurrent or co-tenancy. Joint tenancy deceased. It is a partner's property automatically passes to surviving partner, contrary provisions in will ineffective. Tenancy in common. Interests of deceased partner passes by will, not by survivorship, may encumber, sell, gift, or devise their interest at any time. Tenancy by the entirety. Co-ownership form that can only be used by married couples, created by express wording, and surviving spouse has right of survivorship. Neither spouse may sell gift, devise, or otherwise transfer property without permission of other spouse. Community property. 9 states recognize this form of co-ownership. Applies only to married couples. Each spouse owns 1/2 of assets acquired by income during marriage. Property received by gift or inheritance or held before marriage belong to the partner alone. Condominium. It is a common form of ownership in a multiple dwelling building. Purchasers of a condominium should have a title to their individual units. Own the common areas as a tenant in common with the other condominium owners. Owners may sell or mortgage their units without the permission of the other owners. Cooperative. It is a form of co-ownership of a multiple dwelling building. A corporation owns the building and that the residents own shares in the corporation. According to Thomas Drummond, property has its duties, as well as it has its rights. I hope you have learned something from this video. And don't forget to subscribe to my YouTube channel for more information. This is Ace Magic Casaldo saying, stay at home. Thank you so much.